Hello, everyone, and welcome to today's webinar. My name is Melanie O'Brien, and I appreciate you joining us today. This webinar is being recorded. If you disagree with your name or your attendance being recorded as a part of this webinar, you may disconnect at this time. This is the 8th in a series of webinars that I have hosted this year. We have 2 more to go. The next one will be on September 20th, and the last one on October 18th. We would appreciate your feedback on this webinar series, as well as ideas for webinar topics for next year. You can send your thoughts or feedback or ideas to us at the National NAGPRA program at nagpra_info@nps.gov. As we have done in other webinars, there will be a Q&A option at the end of the presentation. It will only be Q&A. We will only take written comments or questions, I should say, and answers. So there is no option to raise your hand or to ask live questions during this webinar format. The Q&A is turned off right now, but I will turn it on when I finish my presentation. Today's presentation is about determining cultural affiliation. This presentation that I've prepared for today is somewhat similar to a presentation that I gave in 2021 with the NAGPRA community of practice, although it's been updated obviously to reflect the changes in the revised regulations. But this is a good reminder to those of you listening that there are a lot of resources available about NAGPRA and NAGPRA implementation. That includes presentations that I've given at the NAGPRA community of practice, as well as these webinar series, as well as a host of videos that are available on our YouTube channel. If you are not a visual learner or an auditory learner and you want to read material, we have a lot of that too. We have a lot of written information, guidance, frequently asked questions available on our website. So I encourage you, if you have questions about NAGPRA implementation, generally or specifically, to see if you can't find the answer in the materials that we've already provided. I will recommend that you do some basic internet searching to see if you can't find the answer to the question that you're looking for. I would encourage you to inspect the source of the information and certainly maybe not rely on an AI's answer. But there are lots of reputable sources available, including the National NAGPRA Program's website. The very first webinar that we did this year was about our website and about the updates and changes that we had made, both to include additional templates and guidance, but also to the text. So each page of our website contains text and information about the regulations and as clear a language as we could provide. And I would encourage you to be sure that you're very familiar with the information and resources that are available just through our website. And that website is NPS for National Park Service.gov/NAGPRA. So on to the topic for today. So today's topic is cultural affiliation under NAGPRA, and in particular, cultural affiliation under the revised regulation. So to start today, I wanted to remind all of you of what historians call the primary sources for the information that I'm sharing with you today. I also want to remind you that every piece of information that's provided on these slides today comes directly from one of these sources. So while we will post this video and we will post the PowerPoint presentation that I have, this is not the only resource or the only place to find this same exact language and information. Everything on these slides today comes from either the law itself or the regulations or related material. So as a reminder, again, our website has a wealth of information, and in particular has direct links under law and policy to these primary source documents. Of course, the very first source is the Act itself, which you can find a link to on our website. In addition to the Act, the legislative history is contained in 2 reports, as well as some additional material, but primarily in 2 reports, one by the House and one by the Senate in 1990. These are very important resources for everything that I'm going to say and share today, but really for any questions that you might have under NAGPRA. In addition, of course, to the Act is the regulations. And as you are all aware, the regulatory process involves proposed rules that are drafted and provided publicly for comment, and then the final rule that responds to those comments, as well as the regulatory text itself. And again, these are all available on our website. The links here are to our regulations page, where you can find every proposed rule, not just the most recent, but every proposed rule under NAGPRA is posted there, as well as every final rule under NAGPRA is provided there. And all of those sources are publicly available and text searchable. So again, these are incredible resources that allow you to really dig into the explanations for the regulations as they are now and as they have changed over time. So I wanted to structure today's conversation first by getting back to some basics. And I love this image because certainly sometimes discussing cultural affiliation can definitely feel like trying to put a round peg in a square hole, or I should say a square peg in a round hole. It can be quite difficult sometimes to see how the pieces all fit together. But again, the purpose of the revised regulations is to make this easier, to make it clearer, to try to make it easy to fit these pieces together. So looking first again at the overall purpose of NAGPRA, taken from the law itself and the legislative history. The purpose of the law is to recognize the rights of lineal descendants, Indian tribes, and NHOs in human remains, funerary objects, sacred objects, and objects of cultural patrimony. That is the objective of this work. Both the House and the Senate report expand on that overall purpose by saying that NAGPRA is about reaching an agreement on repatriation or disposition, and that it is intended to provide protection as well as repatriation. So those are the basic purpose of the law. In the revised regulations, we've expanded this a little bit to include a purpose statement. The very first paragraph in the revised regulations explains that the regulations provide for 2 systematic processes. One in protection on federal or tribal land, and that's subpart B of the regulations, and the second, subpart C, to restore ancestors and cultural items from museums and federal agencies to Indian tribes and NHOs. But throughout either of these processes, there are requirements for consultation, for reporting, identifying and reporting, and giving notice. So again, these are just sort of the basic outlines of what NAGPRA is and how the process is laid out. Central to this to either of the processes, either in subpart B or subpart C, whether you are protecting or returning, is the concept of cultural affiliation. And this slide shows sort of the 2 sides of the coin when it comes to cultural affiliation. Cultural affiliation is the responsibility, determining cultural affiliation, I should say, is the responsibility of a museum or federal agency. However, the other side of that coin is that determining cultural affiliation must be done after consultation with Indian tribes and NHOs. Determining cultural affiliation is based on the information available without any additional study or research. And the other side of that coin is that cultural affiliation is not precluded because there are gaps in the information that is available. And lastly, cultural affiliation determinations are required to be in a notice, to be given. Museums and federal agencies must make the determination and then provide that information publicly, that determination publicly through a notice. And there are deadlines for producing notices under both Subpart B and Subpart C. So this is actually an image that I had used in that 2021 presentation, and I didn't update the date, but you can put today's date as the present time, because the process in looking at cultural affiliation, and especially in what the revised regulations lay out as cultural affiliation and the process for determining it, are really an effort to go back to 1990 and to congressional intent. So in some ways, I'm asking you to join me in getting in our DeLorean and going back in time here. Because a lot of conversations that I have about cultural affiliation are around what people think cultural affiliation is, as opposed to what Congress intended cultural affiliation to be. So from here on out, I'm focused on the revised regulations, and the bottom of each slide contains a reference to the location in the revised regulations where you can find this exact language. Cultural affiliation is defined in the revised regulations at 43 CFR 10.2, and this is the definition in the revised regulations. Cultural affiliation means a reasonable connection between human remains or cultural items and an Indian tribe or NHO based on a relationship of shared group identity. The definition includes a second sentence. Cultural affiliation may be identified clearly by the information available, or reasonably by the geographical location or acquisition history of the human remains or cultural items. So in the following slides, I'm going to dig into this a little bit more. In addition to slides that go to the regulatory text itself, I have included slides with paragraphs, and I apologize for the amount of writing and reading here. But these are paragraphs that relate to the regulatory provisions from the final rule. And you'll see at the bottom of the slide, there's a link to where in the final rule you can find this paragraph. The link at the bottom takes you directly to that paragraph in the Federal Register. And in this case, it's paragraph 180 that explains a little bit more about the definition of cultural affiliation. And as noted here, the definition has been clarified by incorporating congressional intent to ensure that claimants have a reasonable connection with the material. So that reasonable connection piece comes directly from the House report as well as the Senate report. And the additional language in the definition that's in the Act about tracing through time and identifiable earlier groups are incorporated into the procedures for cultural affiliation rather than the definition. And we'll get to that in a minute, the procedures. We have included in the definition and the regulations the two ways that cultural affiliation may be identified. Again, that second sentence about clearly or reasonably determined. And that is taken from the Act as well. And you can find that in the citation that's listed there in the inventory provisions of the Act itself. And it talks about these two ways that cultural affiliation may be identified, clearly or reasonably. So again, my goal here is to give you what's in the regulations and the explanations that we've provided. So in the opening paragraphs of section 10.3, which is about determining cultural affiliation, is this statement that cultural affiliation ensures disposition or repatriation. So either of the processes, subpart B or subpart C, is based on a reasonable connection with an Indian tribe or NHO. The reasonable connection piece is underlined and bolded here because the next slide explains why that language reasonable was used. Again, from the final rule is the explanation. The final regulations have replaced the phrase preponderance of the evidence with the term reasonable. As we received a lot of comments on this, the terms have different connotations, and preponderance of the evidence has often been misused or misapplied when it comes to cultural affiliation. We agree with the comments in the Act that the Act envisioned a simple and collaborative procedure for determining cultural affiliation through consultation with Indian tribes and NHOs. And it is only when a museum or federal agency was unable to determine cultural affiliation that an Indian tribe or NHO would need to demonstrate cultural affiliation through a preponderance of the evidence. So again, this paragraph in the final rule explains why the term preponderance of the evidence has been removed from this section on cultural affiliation. It still appears in the regulations, and it, as the second paragraph here indicates, it is when an Indian tribe or NHO needs to demonstrate cultural affiliation where a museum or federal agency was not able to determine it in the first instance. So again, the regulations are clear that determining cultural affiliation is about identifying a reasonable connection. And to determine cultural affiliation, again, the two sides of the coin here are that it's based on the information that's available, but that must include information from Indian tribes and NHOs. And cultural affiliation does not require exhaustive studies, additional research, or continuity through time. On the flip side, cultural affiliation cannot be precluded because there are reasonable gaps in the available information. Again, this is a sort of outline of what's in the regulatory language at 10.3. And hopefully for those of you that have been involved with NAGPRA for some time, none of this should sound different or surprising. This is certainly how we have talked about cultural affiliation for a very long time. But again, the revisions in the regulations are trying to make this very clear and to provide clear language to indicate what is required and likewise what is not required for cultural affiliation. Again, in looking at the final rule, paragraph 320 in particular, talks about the term reasonable, and that the initial procedure for determining cultural affiliation only requires a reasonable determination. We were asked to define what reasonable meant, and we have provided here in the final regulations the definition, the standard definition from the dictionary of in accordance with reason, not extreme or excessive, moderate or fair. So again, you can find this particular paragraph in the final regulations. So the regulatory language at 10.3 provides a process, a step-by-step process for determining cultural affiliation. It's 3 steps. The first step is to collect information. Information can be collected from records, catalogs, relevant studies, or other pertinent data, as well as, of course, additional information that might be provided during consultation from an Indian tribe or NHO. Quite often we get asked for assistance by a museum or a federal agency. And the first statement that sometimes they say is, we don't have any information. And then we might ask, well, what does your catalog record say? Or what does your catalog, your accession information say? What do you know about the object? And more so, what do you know about your collection at large? When was your collection founded? Was it cataloged at some point in time and you know that this was there before that catalog point? That's all information. That's all relevant information that you have. And that should be a part of this gathering information part, this first step in cultural affiliation. This is where the list of types of information you can be found. And again, these are the types of information that were provided in the Act itself. And it includes a statement in this paragraph that a lack of any type of information does not preclude a determination of cultural affiliation. So while there's a list of types of information that might be available, it's not a checklist. It's not that everything must be present in order to find cultural affiliation. Rather, it's examples of the types of information that might be available, things to consider when you're looking for that information. And lastly, this paragraph includes a statement in the regulations that one type of information may be used to determine cultural affiliation when no other relevant information is available. So even if you're only able to identify one type of information about the human remains or cultural items, that still is enough to make a determination of cultural affiliation if it is the only information available. So to explain again a little bit more about this first step, and in particular here, the types of information. Again, there is a list of the types of information that can be used, that might be available. And we did receive some requests to prioritize those types of information, but we did not do that because all of the types of information are equally relevant and equally prioritized. Rather, the regulations repeat this exact types of information that can be used for cultural affiliation as provided by Congress in the Act, although we did place them in alphabetical order. And in the category of other relevant information or expert opinion that is in the language in the Act, we have included Native American traditional knowledge, particularly to call out this newly defined type of expert opinion that is highlighted in the revised regulations. So again, if you're not familiar with the revised regulations, Native American traditional knowledge is used in several places in the regulatory text and is defined in the regulations and is included here specifically as one of the types of information that may be used in determining cultural affiliation. This inclusion of Native American traditional knowledge in cultural affiliation in particular is consistent with the congressional intent around cultural affiliation. Again, that requirement to include information provided by Indian tribes and NHOs, as well as the purpose of the regulations, which includes deference to lineal descendants, Indian tribes, and NHOs in making that determination of cultural affiliation. The second step in determining cultural affiliation is to identify the required criteria. Again, the criteria is listed here as 3 parts, and each of these 3 parts must be identified in order to determine cultural affiliation. So first, the information that you collected in step 1 should be reviewed to see if you can identify these 3 criteria. 1, that there's an earlier group connected to the human remains or cultural items. 2, that there's an Indian tribe or NHO. You can identify 1 or more Indian tribe or NHO. And 3, that you can trace a relationship reasonably between 1 and 2. That is cultural affiliation. That is the criteria that is required for cultural affiliation. These three elements must be identified. We go on to say in the regulatory text itself, under 10.3b, paragraph 2, that one type of information may identify criteria when there is no other relevant information. Again, we stated this in paragraph A, we've stated it again in paragraph B in step 2, that one type of information may identify the criteria. And in this case, we've provided in the regulatory text an example. Geographical information may identify, 1, an earlier group of people that is connected to a geographic location, 2, an Indian tribe or NHO that's connected to that geographical location, and 3, a relationship of shared group identity. Sorry, I misspelled identity there. It should be identity between the two that is traced through time. So again, the type of information collected in step 1 one type of information, geographic information in this example, can be sufficient to identify all 3 criteria. And here's our explanation of this from the final rule. Again, the goal here in step 2, and in particular with this example of geographic information, is to realign the geographic analysis that previously was applied to culturally unidentifiable human remains to cultural affiliation. So those same methods, analysis, and sources and evidence that might have been used in the previous regulations for culturally unidentifiable human remains can inform a cultural affiliation determination based on geographical information. We received a lot of comments that museums and federal agencies had been overly expansive in designated human remains and associated funerary objects as culturally unidentifiable. This was a central problem or issue that these regulations were trying to address. And based on the information we have about human remains that have been reported under NAGPRA, in most cases, there is sufficient information about geographic origin as well as acquisition history that could be used to either clearly or reasonably identify Indian tribes or NHOs with cultural affiliation. So again, we're clarifying here why this example of geographic location is provided in the regulations and the reasoning behind the statement that geographic information in some cases, and perhaps in most cases, can be used to identify cultural affiliation. And the final step, step 3, is to make a determination. So let me just take a minute here to step back, because I think that I probably should have made a slide that just listed the 3 steps, because they're really quite simple, although I've tried to provide a lot of information on each slide. The first step is to gather information. The second step is to identify the criteria. And the third step is to make a determination. They're really intended to be very simple steps. Although, again, we've tried to provide a lot of guidance and information about how you do this, how you complete these 3 steps. But the overall process of cultural affiliation and making this determination is collect the information, review it, and then make a decision. That's it. That is the cultural affiliation process. So in making a determination, again, as I stated earlier, it is the responsibility of a museum, federal agency, and in some cases, the Department of Hawaiian Homelands, again, DHHL. And the museum, federal agency, or DHHL must make a written record to describe the information that is available, step 1, and the criteria that was identified, step 2. And then the decision is one of 3 things. Cultural affiliation is clearly identified, cultural affiliation is reasonably identified, or 3, cultural affiliation cannot be identified. Those are the 3 options in determining cultural affiliation. It must be one of those 3. Clearly, reasonably, cannot. Again, the goal here is to have a clear determination from a museum or federal agency after completing steps 1 and 2 for what their decision is on cultural affiliation. I will point out that there are only 3 options here in making a determination. There's not an option to say, I don't know. There's not an option to say, I don't want to figure it out. And there's not an option to say, I'm going to let somebody else figure it out. No, a museum or federal agency has an obligation to make a determination on cultural affiliation. If you remember back in those early slides, that determination, that decision on cultural affiliation must be provided in a public notice and must be then within a certain time frame. So there is an obligation here for museums and federal agencies to make these decisions. So in looking a little bit more at the first 2 options, cultural affiliation is clearly identified or cultural affiliation is reasonably identified. Those options come directly from the Act. As I noted before, it's in the inventory section under notification. It provides 2 ways that cultural affiliation might be determined. Clearly or reasonably is how we've termed it here. In the Act, cultural affiliation of human remains, and this is in particular human remains, but applies also to cultural items, may be clearly identified or not clearly identified, but determined by a reasonable belief given the circumstances surrounding acquisition. So again, the citation to the Act is there, and it is this language that we've used from the Act to identify these first 2 determinations. Throughout the inventory process, there's a reference to an inventory identifying geographic or cultural affiliation, geographical origin, facts surrounding acquisition and accession, tribal origin, and totality of circumstances. So we've taken all of that and simplified that language into the 2 options, and I'll go back to the screen. That cultural affiliation is clearly identified by the information available, or reasonably identified by geographic location or acquisition history. So again, all of that language from the Act is what has been used to come up with those first 2 determinations on cultural affiliation. Now we use the term acquisition in making a determination on cultural affiliation. So we've talked a little bit about geographical location already, and here I wanted to highlight what we say in the final rule about acquisition. Acquisition, used in the Act, is not defined in the Act, nor is it defined in the regulations. So again, it should be understood to have a basic dictionary definition, which the definition here is taken from Webster's dictionary. Acquisition means to get as one's own, to come into possession or control of. To try to elaborate and clarify what acquisition means in both the summary and inventory sections of the regulations, we talk about provenience and provenance, both of those meaning origin, source. Provenance meaning origin or source. Let me step back. Both of them mean origin or source, but provenance is the history of ownership, where provenience tends to refer more to the geographic location. So we've clarified geographic location as provenience and acquisition history as provenance. Again, the terms are maybe helpful in the detailed specific context of collections. Knowing where something came from versus when it was acquired is the basics of these 2 these 2 points. It's the geographic information and the acquisition history that can be used to determine cultural affiliation. Okay. In addition, in the final rule, we explain beyond just the definitions that museums and federal agencies must identify both the geographic location and the acquisition history. And there are a small number of cases where geographic location is unknown, so where something was taken from. But generally, all human remains and associated funerary objects, as well as other cultural items, have some kind of acquisition history or provenance. Even when the only information about human remains is that they were found in collections of a museum, that is information that can be used to identify consulting parties, obviously, and then after consultation could be used to determine cultural affiliation. So again, acquisition history itself, what you know about an object and when it arrived to the museum or the date that it was before, at least, is sufficient information to begin consultation, and then based on that consultation, to determine cultural affiliation. Again, this is just all explaining the language that is used in the regulatory text. The second part of step 3 is clarifying and often a point of disagreement that we have heard frequently, although it was very clear in the previous regulations, and again, we've tried to make it very clear in these regulations, that more than one Indian tribe or NHO may be culturally affiliated. Cultural affiliation is not a one-to-one relationship, to use a database term. There are multiple possibilities for how these relationships may be traced and identified. So for example, and again, these examples are in the regulations themselves, an identifiable group may have a relationship to more than one Indian tribe or NHO. There might be multiple earlier groups that are connected to human remains, and a relationship may be traced to more than one Indian tribe or NHO, even where that Indian tribe or NHO does not have, between themselves, do not have a shared group identity. In addition, the regulations provide additional information in this paragraph about cultural affiliation in Hawaii in particular, where 2 or more Native Hawaiian organizations may be a part of the same community, but have distinct beliefs and protocols, meaning that they have separate lines of cultural affiliation, but are still could be culturally affiliated. In each definition of Indian tribe, lineal descendant, and Native Hawaiian organization, we have clarified that while the term might be used in the singular form, it is expected that multiple Indian tribes, NHOs, or lineal descendants may meet the criteria for disposition or repatriation. And cultural affiliation may be to multiple parties. And in those cases, any party with cultural affiliation may submit a claim, for disposition or a request for repatriation. And joint disposition and joint repatriation is obviously permissible and clearly outlined in cultural affiliation. I include this here again just to clarify and to remind those of you that we had identified this as an issue, something that had been raised in the past 34 years of NAGPRA, this idea of multiple Indian tribes or NHOs with cultural affiliation. And we wanted to be very clear in these regulations that even when Indian tribe is singular, it may be that more than one Indian tribe will meet the criteria for cultural affiliation and certainly for disposition and repatriation. Okay. The last section of my presentation today are some scenarios. I have 4 scenarios here, and these scenarios again are taken from the presentation that I did in March of 2021 to the NAGPRA community of practice. However, in that presentation, I provided some results, some outcomes maybe of a certain scenario. I've removed the outcomes here because I wanted to actually propose this as a bit more of a scavenger hunt for those of you who might want to have some fun with this. Each of these 4 scenarios, while I created them, they are hypothetical, they are made from my own experience and understanding, are not disconnected from reality in any way. And in fact, I think that if you wanted to take a look at each of these 4 scenarios, you could go to the Federal Register notices that have been published since January 2024, and you could find a notice that matches each of these scenarios. Now, in fact, I will say that I think you can find multiple notices that match each of these scenarios, and you could see then what museums or federal agencies decided to do. What's important about these scenarios and the scavenger hunt is, again, it's not a one-to-one relationship. There is not one right answer to each of these scenarios. In fact, for each scenario, I think you can find multiple notices that come to different conclusions about cultural affiliation in particular. So I'm going to go through each of the scenarios and leave it as a sort of open question for you all to look into if you want, in how museums and federal agencies have made the determinations on cultural affiliation. Okay, so here's a scenario. For human remains, the only information about those human remains is that there's the geographical location from where they were removed. So the provenance or the geographical location is the only information. The museum, through consultation, has not been able to identify an earlier group or groups connected to that geographic location. So there's the first scenario for you. There's no earlier group that can be identified. If you go to the Federal Register, or I should say, if you go to our website where we have all the Federal Register notices that are published, and you look just at those were published since January 12th, 2024, you will find multiple notices that reflect this scenario. Here's another scenario. Again, same basic information, geographic location. The human remains are not dated to a particular time period, but they are within a scope. There are earlier groups that can be identified, different groups, 3 different groups based on time period. And there's a present-day Indian tribe that is related to that geographic location. Although it's important to note here that the time the tribe has been identified as being in this location is after the groups, the earlier groups. Again, you can find this scenario in Federal Register notices, and you can find different answers to the question of are these culturally affiliated or not, based on this same kind of information. A third scenario where you have 2 earlier groups that can be identified, and each of those earlier groups have different Indian tribes that can be traced a relationship to. But Tribe A and Tribe B do not themselves have a shared group identity. And then the 4th scenario has a lot more detail. Again, geographic information is known. There's archaeological evidence. There's anthropological evidence. There is some information about dates of the burials. There is a limit to when burials occurred. There are treaties on this location. There's oral tradition from the tribes. One tribe with a treaty tribe has an oral tradition that they came to the area earlier than a tribe that does not have a treaty for that area. who says that the tribes arrived much later. So maybe some conflict there in the oral tradition. Also some conflict in the anthropological record. An anthropologist report has some dates, but a recent master's thesis suggests some different dates. In a scenario like this, where there's actually quite a bit of information, then what is necessary in determining cultural affiliation is to sort of separate this information into groups of what information demonstrates cultural affiliation and which information shows there was no cultural affiliation. It sets up a way of evaluating the information by looking at what supports cultural affiliation and what does not support cultural affiliation. Again, here you can see that they're equal, right, in terms of the number, pure number of information for cultural affiliation and against cultural affiliation. So the next step in this process of evaluating the information would be to assess the information themselves, and is there anything that casts doubt on the information that maybe suggests it's less accurate and maybe should be given less weight in this for and against effort. This slide gives you some ideas of where information for might have a greater weight. And this slide gives you information where you might evaluate the same information and see, based on the context, again, that the information against cultural affiliation has a greater weight. In evaluating the information, it is important to remember that each determination of cultural affiliation is an independent analysis. And all information must be given consideration. The source and the content of the information is important to consider. In evaluating information and making this determination for cultural affiliation, you cannot exclude available information. So if you have information, you must include it and you must consider it. And what is very important is to not treat a lack of information as information for or against. A lack of information is not information. Again, this is where there is a significant amount of information in this scenario. And you, as a museum or federal agency, in making your decision, need to sort of evaluate the information, put it into context, and to make, again, that determination of cultural affiliation. I'm going to step back to a slide and then open the Q&A for questions. So start thinking about your questions here. I'm going to leave us on this slide because I think that a lot of the questions might be able to answer in reference to this. If you'll just give me a minute to allow Q&A. Okay, the Q&A is now open. As a reminder, you can upvote a question. So if somebody asks a question and you have the same question, then you can like it and it will raise up in my list of questions. Okay, question. You stated that all lines of evidence have equal weight in determining cultural affiliation. However, in the final rule, it states that museums and federal agencies must defer to Native American traditional knowledge. That sounds like traditional knowledge as a line of evidence should have more weight. Thank you for the question. In the regulations, that is correct. There are multiple places in which it talks about deference to Indian tribes and Native Hawaiian organizations. And that deference comes in related to Native American traditional knowledge, and certainly is an important piece of a decision-making process, whether that is the decision on um, the duty of care requirements, a decision on cultural affiliation, a decision on repatriation. That deference is a critical piece. However, in looking at the lines of information that are available, they are all equally relevant, meaning that Native American traditional knowledge does not have more weight. If you think back to that, the for and against slide, if you're looking at Native American traditional knowledge as one of the pieces of information you have, and it is for cultural affiliation, and you have other information to suggest that there is no cultural affiliation, then you need to consider all of that information, and all of that is equally relevant to your decision making. I want to clarify, the question says equal weight, but that's not accurate. They're all equally relevant. The weight, the sort of for and against element, is when you have competing information and you need to evaluate the context. So it is the information itself that you weigh. Say, let me fast forward to that slide, because I think I have some good examples of how you might question different kinds of information. For example, traditional knowledge, oral tradition, from multiple tribes give a particular date for a tribe or a group's arrival in a location. That multiple tribes information gives that information more weight than on the other side, where oral traditional, Native American traditional knowledge, again, you might have the same category here. That oral tradition about a neighboring enemy tribe. So that information has some doubt to it. There's some question about that information. Even though it's against affiliation, cultural affiliation, it has maybe you have some concerns about it, that piece of information. So the weight here is in looking at the information itself. It's not in comparing the two sides, if that makes sense. Similarly, remember I provide this other example of ways that, so for example, here, if multiple tribes agree on a later date of arrival, that might be a way that one piece of information might have different weights. Again, it's going to depend on the very particulars here. Okay, so again, a reminder that you can ask questions and you can upvote. I'll try to clarify when I read the questions, if there's anything ambiguous or unclear in the question itself, I'll try to clarify it. I'll also try to note when the question is related to the topic at hand or maybe slightly different. This question is actually about consultation and communication. If we have collections from a specific tribe that has not returned any communication, how can we go about repatriation if that specific tribe doesn't respond? Thanks for the question. This is a really important one, and one we get quite often. The answer depends first on what kind of collection we're talking about. So in the case of human remains and associated funerary objects, the museum has an obligation to make decisions about cultural affiliation in its inventory and publish a notice within a certain time frame. That time frame is either 2 years from when the collection was acquired or 5 years from the date that the regulations were final, depending on whether you've reported this collection before or not. So let's assume that you reported this collection of human remains in 1995, but you've never heard back from a tribe. You have an obligation now to reach out again, consult if they respond, but if they do not respond, you still have an obligation to make a decision about cultural affiliation by the 5-year deadline. Even if the tribe never responds to you, you still have that obligation to make the decision on cultural affiliation and to complete your inventory and publish a notice based on what you do know, based on the information you do have. The answer is different if we're talking about cultural items that are not human remains or funerary objects. In that case, your obligation is to inform tribes that you have the collection through the summary process, a general description, but then you have no other obligation to act until you hear from a tribe for repatriation. So there may be, when it comes to cultural items that are not human remains or associated funerary objects, it may be that you can't go about repatriation until you have heard back from a tribe that they're interested or making a request for repatriation. There's a follow-up on that about could you then conduct research on the collection? You cannot conduct research on a collection of either human remains or cultural items that are NAGPRA cultural items until you have consent under the duty of care requirements. All right. The next question is, again, you can upvote questions if you have the same question. Takes me a minute to get it to sort it. I wish it did this automatically. The next question is, can tribes appeal a federal agency decision regarding affiliation? Thanks for the question, and Stephen Simpson with the Solicitor's Office has answered it. In terms of a federal agency decision, and a decision by a federal agency and how that plays into what is called the Administrative Procedures Act and a final agency action that is a part of the Administrative Procedures Act where you can formally appeal a decision by a federal agency. And I appreciate Stephen's answer, but I want to step back a little bit and say that there's a piece of this that we did not discuss, and that is referred to on a slide. So let me get there. Yeah, so your question, well, Stephen is correct about final agency action and the Administrative Procedures Act and the process for appeal or challenging a decision on cultural affiliation. I also want to point out that in the human remains and associated funerary objects process, where a museum or federal agency, for that matter, either one, makes a decision that there is no cultural affiliation, or that there is cultural affiliation to tribe A, for example, they must complete an inventory that says that and publish a notice that says that. So it says cultural affiliation to tribe A or no cultural affiliation. At that point in the regulatory process for human remains and associated funerary objects, a tribe can make a request for repatriation that states they are culturally affiliated, whether that's tribe B in the case of tribe A's affiliated, or where the museum says there is no cultural affiliation. There is an option in the process, in the basic process. This would be step 6 under the 1010 section, I believe, where a tribe can make a request for repatriation. After that notice is published, and in your request, provide the information to show cultural affiliation. So it's not quite an appeal, and it's broader than just federal agencies, but I wanted to be clear that where a museum decides there is no cultural affiliation, we have built into the process in the regulations the option for a tribe to make a request for repatriation, even in those cases where a museum says there is no cultural affiliation. The tribe must show by a preponderance of the evidence that it is culturally affiliated. But that is an option in response to a notice. All right, the next question is, to what extent is geographic location interpreted? What boundaries are considered? What historic or anthropological data must be taken into consideration? What are the limits? There are no limits on what is geographic location. Geographic or geographical, as is used in the regulations, means what it means in the dictionary. It means a place on a map, essentially. Geographical information or geographical location means where the objects were removed from. And it's separate from acquisition history. If you remember that slide where we talk about the difference, or at least the definitions of acquisition history. So acquisition history is the history of the collection or the museum. Geographic location has to do with where the objects were removed from or taken from. And the connection that might be made to demonstrate cultural affiliation based on geographical location has no limits. I mean, any historical or anthropological data should be considered if it's available to the museum, as well as oral tradition, Native American traditional knowledge about locations and where people lived should be taken into consideration if it's available. So I will step back and say I think the limits on your question are about what information is available. And I want to be very clear that we're not talking about information that exists in the world. We're talking about information that the museum has. I heard someone say a while ago that sometimes it can seem like museums or federal agencies are waiting for information to fall from the sky to make a decision. And this was actually not in NAGPRA context, but just in general other context. And I think that's appropriate here because it's not that you have to wait for the information to fall from the sky. You have to take the information you have and all of the information that you have and to consider it in making a decision. So I think the limits are what's available, what is available to you. There is no requirement in NAGPRA to find information that exists. Rather, the obligation is to collect the information that is available to you, to your museum or federal agency. Okay. Another question in this case related to somewhat to the topic we're discussing today, but also to the topic that was discussed at the last webinar on July 19th. Information available for affiliation points to a non-federally recognized tribe. In this situation, it is a cemetery named after their tribe for which they hold the deed to the land. Okay, there's a lot of specific information that connects the human remains to a non-federally recognized tribe. And while that is very important information and information to consider, it is not information for cultural affiliation. Because cultural affiliation is limited under NAGPRA to federally recognized tribes or Native Hawaiian organizations. So while the information may show that there is a shared group identity, a reasonable connection, it is not the same as cultural affiliation as that term is defined in NAGPRA, because that is limited to federally recognized tribes and Native Hawaiian organizations. So therefore, you would need to look and see if there is any information available about cultural affiliation to a federally recognized tribe. If there is not, then there may be no cultural affiliation, and that would be the decision of the museum in this case, that there is no cultural affiliation because, again, cultural affiliation means a reasonable connection to a federally recognized tribe. Okay. Let's see, the next question with the most upvotes is if I could provide a definition for the word deference. I cannot, that term is not defined in the regulations. Let me see. I think that we discussed this. Well, I think that we provided additional information about deference in the final rule. And it may have included the dictionary definition of deference, or defer, I think, actually, maybe what we defined. But again, we did not define it. We looked to a standard dictionary definition for that term. I'm sorry, I'm not able to pull it up quickly. I would encourage you to look again in the text searchable Federal Register format of the final regulations for the 37 times the word deference is used, and to see if that assists you with understanding what the definition means. But again, you can also look at Merriam-Webster for a definition, a standard dictionary definition. Okay, what does one do if more than one tribe has cultural affiliation? Moreover, additional question, an equal claim, but they do not agree to a joint disposition or a repatriation. Thanks for the question. We tried to, I want to be very clear. This presentation has focused on determining cultural affiliation. And while I mentioned that multiple cultural affiliations is possible and probable, I did not address the issue of competing requests or claims. I did that intentionally, and I did it intentionally because a lot of times in starting out a discussion on cultural affiliation, we are asked what happens if there's a disagreement. And our answer is wait until there's a disagreement to figure out what happens. That aside, I understand that you may be in a situation where there is a disagreement or a conflict, and that's okay. And what we've tried to do in these regulations is lay out a very clear process for museums and federal agencies where they have made a decision of cultural affiliation, and this is key. In the first place, you have to make the determination. And if you've identified more than one tribe with cultural affiliation, that's your decision. After that, if you have multiple competing requests, so not joint requests, not joint claims, but competing requests or claims, then there's a process that's laid out actually in 10.3 for identifying the closest culturally affiliated tribe or NHO. So, but again, only when there are competing requests or claims. Then do you have to determine the closest cultural affiliation. And again, a museum or federal agency must make a decision. They must determine if they can identify the closest culturally affiliated tribe. This process is laid out in subpart C under the heading Evaluating Competing Requests. And I would encourage you to take a look at that if you're in a situation where you're dealing with this. There's a process by which a museum must, or federal agency must notify the parties of the competing requests and then make a decision if they can identify a most appropriate requester. So again, I left it out intentionally because in the first instance, you shouldn't approach a question of cultural affiliation with a potential for conflict. Rather, you need to base your cultural affiliation decision based on the information that's available and that includes consultation, and maybe there's competing information, but that should contribute to your decision on cultural affiliation. If you get down the road and you're in the place of competing requests or claims, then there's a process for that. Let me resort here. How can a museum or agency determine which tribe to repatriate to if two tribes are made up of the same people? Okay, I'm gonna stop sharing so I can maybe read the comments a little easier with and a little faster. So let me step back and clarify this question. Nowhere in the regulations does a museum decide who to repatriate to. Rather, museums are obligated to make determinations about cultural affiliation. And then, after a decision on cultural affiliation, to receive requests for repatriation. So I think that how do you decide between a request for repatriation from two tribes that are competing requests? Then you look to, again, the process that's provided for evaluating competing requests and for identifying the tribe with the closest cultural affiliation. It may be that in the circumstance you're describing, the museum cannot determine who is the most appropriate requester. And in that case, then there's a provision in the regulations in subpart C for a stay to repatriation. So where the museum or federal agency cannot determine who is the most appropriate requester between two competing requests, then that pauses the process of repatriation until there's some other resolution. So the answer to your question is a museum does not decide who to repatriate to. All right, the next highest question here. How do you go about following up with affiliated tribes about objects or human remains published in NICs and summaries that have not been claimed? So even through NAGPRA compliance, even though NAGPRA compliance has been fulfilled, how do you follow up with tribes to get a determination on whether or not they want to claim these items? It's a great question, and one that I know a lot of museums face. I want to say that there was a NAGPRA community of practice presentation on this issue in particular. I know that it's an issue many museums and federal agencies have discussed and talked about process or approaches to this. I can't give you the answer because this is not in the regulatory process. The regulatory process requires museums and federal agencies to make decisions based on information and consultation and to give public notice. But once that process is complete, it then is up to the tribe for NHO in the case of human remains to make a request for repatriation. And it may be that they don't make that request. And so there are a lot of answers for how you might go about that. But I can't give you any instruction here because again, that's beyond the regulatory requirements and the regulatory process. I would highly encourage you to look in the community of practice videos to see if there is a video about this topic, or perhaps even to seek some support from others in the NAGPRA community of practice or within your own professional network. Okay, if a museum determines that cultural affiliation cannot clearly or reasonably be determined for human remains and submits a notice with that decision, what are the options for, I'm going to say, transfer of those human remains? Thanks for the question. We did address this a little bit in the last webinar. And I will say that the options after publishing a notice that says there is no cultural affiliation for human remains, those options are in paragraph 1010K, as in kangaroo, of the regulations. And there are options to transfer human remains and associated funerary objects to any Indian tribe or NHO that is willing to accept them, or the museum can also decide to rebury or reinter those human remains and associated funerary objects. There's a process for that. It requires an additional notification, but those are the options. Again, that's in 1010K of the regulations on repatriation of human remains and associated funerary objects. Thanks, Lisa, for adding a link to where that is in the regulations. Question, does the NPS website have a page with a table listing deadlines applicable to the determination of cultural affiliation? Thanks for the question. Yes and no. So there are tables with deadlines, and those are under each of the main sections under compliance. So under compliance, there's a section for protection on federal or tribal land with the timelines associated with that. There's a section in the website under compliance on repatriation of human remains and the timelines for completing an inventory and publishing a notice. And then the third piece is there's a section on repatriation of other cultural items, again, with the timelines for reporting, for compiling a summary. And the timelines really are related to determining cultural affiliation are attached to those processes. So as I mentioned, a determination of cultural affiliation for human remains and associated funerary objects is in the provisions for repatriation of human remains and associated funerary objects. So related to complete, there's two deadlines. A deadline to complete complete or update an inventory, and a deadline to publish a notice. For other cultural items, there's a deadline to compile a summary. There's not an associated deadline for determining cultural affiliation of a summary. However, there is a deadline for responding to a request for repatriation, which is when cultural affiliation is determined. So hopefully that's an answer to your question. I know it's not as clear as a table on cultural affiliation decisions, but it really does depend on what you're talking about. Again, there's the two main processes: protection on federal or tribal lands and repatriation by museums or federal agencies. And then within repatriation, it depends on whether you're talking about human remains or other cultural items. Kind of like a decision tree. Kind of got to figure out where you're going to start. Okay. When you say that a museum must publish a notice when it has determined cultural affiliation, I'm wondering if it's different for human remains and associated funerary objects versus other cultural items. Yes, it is. Thank you. Yes, for human remains and associated funerary objects, the notice follows completion of an inventory. That's why the notice is called a notice of inventory completion. But for other cultural items, the notice is published once a request for repatriation has been received and accepted. So for other cultural items, the notice comes after a request for repatriation, and an evaluation of that request. The museum determines there is cultural affiliation. It publishes a notice that says there is cultural affiliation for other cultural items. And again, this is only in subpart C. But yes, there's a difference for when the notice is published based on what kind of object you're talking about. Again, that's where the step-by-step can be very helpful. And I'll mention that we produce these steps to repatriation documents. These are the colorful versions. There's also a plain text version, both for human remains, and I'm sorry, this is backwards, and for cultural items. But you can find these steps to repatriation on our webpage. It gives each step for each kind of object, whichever one we're talking about. And then there are associated timelines included in those steps. So, here I've printed them in color and put them in plastic sheets because I referred to them so much. So please, I encourage you to do the same. Okay, let's see. Agency person drafting a treatment plan for inadvertent discoveries says, according to NAGPRA, they cannot rebury the remains because affiliation must be determined and published before reburial can be accomplished. Thanks for the question. So here we're talking about subpart B and the protection on federal or tribal lands. The federal agency is saying that after a discovery, they cannot rebury the remains because of the affiliation decision. I would say that that's inaccurate. That's an inaccurate read of the regulations. Now, a federal agency could say they can't rebury immediately due to other requirements. I'm not saying that the answer is wrong. I'm just saying the reasoning, at least as expressed in this question, is inaccurate. Cultural affiliation doesn't prevent a reburial, of immediate reburial. And in fact, a plan of action could include immediate reburial as the preferred treatment by the consulting parties. That is acceptable. We outline that specifically in the final rule as well as in the proposed rule. And we can help you find that citation directly. Certainly an option. Now, whether a federal agency agrees to that plan is another issue, and whether there are other concerns the federal agency might have or other issues it has to resolve related to that plan, that would be outside of NAGPRA, and I can't speak to that. But NAGPRA does not prevent that possibility. But again, that's what the plan of action is intended to do, is to provide that preferred treatment of any human remains that are discovered. Okay, let's see. It looks like I have about 8 minutes left. And again, I'm always have more questions than I can answer, but I do want to remind everybody that we do have a record of all your questions, and we're working on compiling what is now a gigantic list of questions and answers, and looking at how we can provide that. Okay, the next one is, we have an unnamed university that wanted the tribes to determine cultural affiliation. They only sent us a list and asked us to identify. We kicked that request back to them and told them to do their job. Thanks for the question. As I stated in the beginning, determination of cultural affiliation is a responsibility of a museum or federal agency. Now, that decision must be done with input and consultation with Indian tribes and NHOs. And so a university may have asked the tribe for their input on cultural affiliation. But that's quite different than the example here of a list and asked to identify cultural affiliation. How a tribe responds to that kind of inquiry it is really up to the tribe. And I would say that the response here to have the museum or federal agency do that effort, and in this case, the university, is important. I will add that, Indian tribes and NHOs are entitled to information from a museum or federal agency about the collection. So a list may or may not have all of the information that's available, and that information is key in making that decision on cultural affiliation, which is the responsibility of a museum or federal agency. And for human remains and associated funerary objects, must be done within a certain time frame. All right, so we have another question here on definition of traditional knowledge. The dictionary definition suggests traditional knowledge should outweigh contradictory evidence. The definition for deference, which, thanks to David Tarler, said is in comment 23 of the final regulations. Deference is a verb related to defer, to delegate, to submit to another's wishes. It goes on to talk about the dictionary definition. I wouldn't, okay, so the definition of deference means to submit to another's wishes, of course. If you look in the regulatory language, there's a requirement for deference to Native American traditional knowledge. That is true. The word deference does not appear in the list of types of information or in the process for determining cultural affiliation. So I want to be clear that deference throughout the regulatory process, it is not related to the equal types of information for determining cultural affiliation. So I don't want to minimize the role of deference in the regulations and in the regulatory process. You could think of it like this, and I hope that this is clear. Where a museum or federal agency has discretion in their decision-making, they should defer to Native American traditional knowledge and to the input from tribes. Determining cultural affiliation, while a decision of the museum, is based on information available and that information being treated as having equal relevance. So I hope that that makes it clear what the distinction is and the difference here. Just because you have Native American traditional knowledge as a part of your information for cultural affiliation does not mean it outweighs other information you have about cultural affiliation. Museums and federal agencies must do this work. They must evaluate the information and make a decision. That's the requirements of cultural affiliation, is to make that decision. And perhaps I could point to the previously answered question from a tribe that was asked to make the decision. It's not the responsibility of a tribe to make that decision. It is the responsibility of a museum or a federal agency. A question about when the inventory template will be available. Thank you for that. I believe we have an itemized list, both guidance and guidance document, as well as a template for the itemized list. Both of those provide a sort of outline for how you might put that information together, and there's a wide variety of that. In terms of a template for an inventory, we have perhaps we're kind of behind, and I'm sorry on getting these templates out, but you can rely, of course, on what you've done previously. Certainly, museums have been producing inventories for 34 years under NAGPRA, and that's an acceptable form to start with. You can look to the regulations for what is required in an inventory. It's not much beyond what's in the itemized list, except for, I will say it's very important to include information from consultation. So if you were to look at the inventory requirements under 1010D, it is an abstract of the itemized list, the names of all consulting parties, and a decision of cultural affiliation. So I appreciate your request, and we're working on the template, but we're, I guess our hope is that what we've given you and what's in the regulations gives you what you need to be able to create an inventory. Certainly don't wait for a template to produce an inventory. If you send something to us and it is missing information, we will be sure to let you know. Lisa shared a link to the steps for repatriation, and I see that we are out of time. So I appreciate your time and attention and all of your questions, and I apologize that I wasn't able to get to them all. And I want to again appreciate the support from my team members in answering questions when they were able to. So thank you all for joining me. I hope that you're able to join us next month on September 20th for the next monthly webinar. Have a great weekend.